that you are with LSG Investment. LSG Investment has been a real estate company that we have seen that has been playing by the books. So when we mean by the books, all regulatory and compliance to acquire land in Lagos is what they have been doing to make sure that they are buying safe and so that you can sell safe. So I want you to give a round of applause for LSG and also for yourself as well. Okay, now to the question. Unfortunately, the question is double-edged because it is the type of land that is in question that will determine the sort of resolutions. Now, if we are talking about a land like a virgin land, a land bought from family community, how to resolve such type of land is different from a land that has a C of O or a land that the approach in both situations would be different. Assuming that it is a land that's bought from the family or from the community head, in Nigeria generally, the sort of person can acquire, you can acquire customarily and legally. So legally means you are buying a land that has a title already, C of O, government's consent, government allocation depending on what type of land it is. So if it is a land that is not registered, then we are talking about customary ownership, land, family land, or community land. So now, if we are talking about family land, number one, the first point of contact is the family head and the secretary and the principal members of the family. Very important. So I expect that before the dispute arises, be at the point of buying such type of land, you must have interfaced with, very important, the family head. Second, principal members, secretary of the family. It is very important that at the point of buying a land, there are principles of law cases that says that if you buy a family land without the consent of the family head, the land is voidable. Yeah. So what does it mean by voidable? Voidable means that if the family head comes in, finds out that people behind him have sold family land, he either has the right to consent and say, okay, I ratify it, go and bring the money, or say, we are not selling, go and return the money back. So it's voidable in that instance. But the family head can sell without the concurrence of the family. So it shows that the most important person in that circle is the family head. Same applies to community head and the executive, the community head and the cabinet. So community head means either the bank or the king. So if you are talking about community land, the king is the banner is the number one person. Without his concurrence, the land is voidable. It's either he ratifies it or he says no, we are not selling. So, but if you buy from persons that does not have the concurrence of the king, it is void, ab initio. So now, to resolving the dispute in respect of, so the first thing is you have to now retrace your step. In the problem with buying customary land is that there is no adequate documentation of who land has been sold to. A lot of them sell land without survey plans. So when they sell land to Mr. A, the Baba has collected money. And then Mr. B comes around, they sell the same land Probably Mr. A did not even know. Mr. A, who is the family head, will not follow them to the site of the land to even know that maybe they have sold the same land to the same person. So at the end of the day, we have issue of land has been sold to 2, 3 persons, and at the point of development, we have 2, 3 persons physically on the land. So what happens? So we have to go back to where the land has been sold, the family, and they would have to resolve that one way or the other. One of them is refunding land, refunding the money from the persons who bought after the first. As they say, equity says the first in time prevails. So the person who buys first should be able to retain the land. Then they refund those who buy after. That's one. 2, they can relocate any of the subsequent buyers. They can relocate them to other lands within the same area of the same value. So, and that's another option. Another option is to say, okay, we have another land in so place, it is of higher value, put more money, we take you there. And so it is very important. And another thing is, at the point of purchasing such type of land, it's very, very important that you allow the family to do the survey plan so that you will be sure that you are getting the identity of your land, the land you are purchasing is clear from the get-go. Survey plan is very, very important as stated by the surveyor. Very, very important because without the survey plan, the identity of your land is still not clear. Even if I have a case in court now, we are 2 on the same land, physical land. We are 2 dragging the same land. But when we got to court, the court will say, okay, from the way both of you have been describing how you got to the land, it seems you are talking about different land. So submit your respective survey plans to the survey general to do a composite survey plan. And at the end of the day, we found out that the survey plan of the other person is several miles away from the land is claiming. So that way, the survey plan has resolved that issue because the court already saw that the way from your narration. So when they did this composite survey plan, it shows that one person owns this land. The survey plan of one person points to the survey plan of the other person points to another place. So it opens the possibility that we are talking about different lands. So that is very important to resolve such type of family land or communal land. Is to go back to the family or community where the land is bought, resolve with them to refund, get alternative land, or get relocated one way or the other. That matter can be resolved. I think with families and community land, it is mostly about money. If money can resolve it, I don't think it will turn to an issue, except you don't like where you are relocated to. Then you can say, I just want the money. So that's in respect of that. In respect of the land, registered land that has C of O, registered deed, and so on. So there's really not much problem with that type of land because if you have done your due diligence from the get-go, the most common type of problems one would encounter with registered land is that if you have not done your due diligence, probably such land has been mortgaged, has been charged, is on lease, and you didn't do your due diligence to find out such type of encumbrances on such land. So you will be surprised that as at the time you are taking possession of the land, a bank will show up and say, oh, this land has, this property has been mortgaged for money, and until the person pays, you can't take possession. So a land that has been mortgaged, a property that has been mortgaged, belongs to the bank or the person that the property is mortgaged to. So you can't apply to. Same thing with charge. Company charge. Company have to raise money. One of the ways company raise money is to charge their assets. So if they charge it, it has the same effect as mortgage. So the property, the legal title belongs to the person the property is charged to. So you only have the documents, but the legal title has already passed to the person that advanced money to the owner. So what are you left with? You have to go back to the seller to say, oh, why didn't you tell me this? Of course, he will tell you that. Why didn't you do your due diligence? So you are also supposed to do your due diligence. So that can also lead to offenses like obtaining by false pretense. Because if you know that you have charged or you have mortgaged your property, and then you knowingly still sell such type of property to somebody else. So but we are not here for that. But how to resolve it is just stricto sensu. Go and collect your money. If the money is not forthcoming, do a petition to the necessary agency and say, I want my money. That's if you are avoiding litigation. But litigation will even take more time. But if you go to the necessary law enforcement agency, your money will quickly come out and you can avoid the litigation. That's it.
Thank you, sir.
Thank you so much, sir. So, my next question, sir, is about what happened to me recently. So, I sold a property with registered survey title, and the client came back to tell me, oh, because the land is registered survey, that means the land is not his. And in my head, I'm like, a registered survey title is a strong title to my knowledge. And you having a registered survey land doesn't mean the land is not yours, but you can't process your own personal C of O for the land. But he insisted that with a registered survey title, that the land is not his. So now, my question is, what is the survey, hold on. What are the most important property documents every realtor should understand? So I would like you to please explain that to us in like 2 minutes. Thank you.
Unfortunately, I won't be able to use 2 minutes for that question, but I will try to quickly. So first, registered survey is not a title document. So let's get that out of the way.
Exactly.
So if there's a registered survey plan in anybody's name and somebody wants to use to sell a property, it is not a title document. Okay. So now, that being out of the way, now we need to understand, to know the sort of title documents that are on a piece of land. We need to know what sort of interest that the person selling has on the land, because that will determine what type of documents you have to ask from the person. So if somebody has a lease, a long lease, maybe let's say a 20-year lease, you can't be asking the person for a deed of assignment. If somebody has, if the property is a mortgage property, maybe a bank has affected his mortgage, and the right to sell has arisen, and they want to sell, you can't be asking some type of person, can I see your deed of assignment? Because you're asking the wrong document. You don't have a full understanding of the sort of interest the person selling has. Because if you understand, you know at that stage that, okay, can I see the mortgage deed? Can I see the agreement between you and the lender? So that would show that you will have a full understanding of the sort of interest that is existing on the land. So first, you have to look at all types of interest. One of them is customary ownership, families. The Land Use Act came 1978, took all the lands from customary ownership and said, oh, all the land are now vested in the governor of the state. So to hold a trust for all the citizens of that state, fine. But several cases have interpreted the Land Use Act to say it doesn't divest customary ownership. So all what customary owners should do is to apply to the state government for a C of O So as at that time, all customary holders of land are holding what they call deemed grants. So when you apply to the state will now give you his own paper to say, we know that you are the one here. So that's for that. Now, from the title, the state can give, then we cannot talk about deed of assignment. Deed of assignment is like when you are holding the land in free. That I think that's the closest title to freehold of the past. So deed of assignment. Then we have some who have a long lease over a property. 50 years lease. There are even debates as to whether the CFO is also a lease, but that's a legal issue. So because when you grant 99 years over a land, it's as if it's a lease, but it goes back to the government, but that's not an issue. So deed of assignment, lease, then mortgage, charge, then vesting asset. What's vesting asset? When somebody who owns a property that has a will, somebody who owns a property that has a registered property and now dies, has children. So in his will, he would have said, I want this property to go to Mr. A or Mr. B. So when they get probate, they do what they call a vesting asset, to vest the property on the person mentioned in the will. So if somebody is telling you that, okay, I have the property I want to sell, the title is vesting asset. That's the correct property. That's the correct title, because he inherited the property through a will. So that's that. Then there's deed of gift. Somebody who has the property and intends to gift somebody, maybe for whatever reasons. So you will execute what they call a deed of gift. So if you have a gift, the property is a gift. So what you should be asking from the person is, can I see the deed of gift? So that shows that you understand. As I said, that's what I said. The sort of interest would determine the sort of documents you have to ask from the person you are buying from. So it is very important, along with the title documents, that you ask for a survey plan as well. Very, very important, because we have seen several cases where the land is saying, oh, I am in Lekki, but the survey plan is saying the land is in yes, we've seen it.
Like
it is
the
not
survey plan showed.
the title document is saying this land
This is
is
funny.
in Lekki, and then the survey plan is saying I am in Badagry. So now the question is, how do we resolve I am in Lekki?
This is
I am in
really
Badagry?
serious.
The safest option is
It's
to
a serious case.
just back out, because the survey plan is what will be used to resolve the title documents anytime issues arise. And if your survey plan is telling you that I'm in Badagry for a land you want to buy in Lekki, so it's better to just that's the big O the person I'm in court with now is struggling with, because now his own survey plan is saying that we are in a different place. So meanwhile we are fighting for a land here. So he has to now say, oh my Lord, don't marry this person. Survey plan, there can be mistakes on survey plan. So to avoid you need to start with Shalani. You need to have the survey plan coupled with all these title documents we have mentioned, to be able to say you have a clear title document. I'm sure I answered the question.
Yes.
Thank you.
Yes.
Thank you,
sir. Knowledge, we really appreciate. Me especially, I'll take that home. So, Ambassador George Nefetisi, so I have a question for you, just a single one. So, what role does personal brand